Hey, everybody. This is Keith Caldwell and Ryan Platt. Ryan, why don't you say hello and introduce yourself?
You got it, Keith. Thank you. This is Ryan Platt. Hopefully everybody's doing well. Um, we do work with Keith to hopefully provide solid information for you in terms of how to structure a plan for your child and all the different pieces of it. We have been doing that for families since 2005 as an organization, and we serve families all over the country in that capacity. So whether you live in Florida or Connecticut or North Carolina or California, we've helped people in all those states kind of put that plan together and answer these questions.
All right, everybody, we are going to dig right into it. Normally, Ryan does a little monologue talking about something. We've got a ton of questions from you. We're going to try to get to as many of them as possible.
It's unbelievable. Thanks for sending them all.
Thank you guys for that. We're going to sort of try to organize it by topic as best we can. So, and if you don't hear your question being brought up, please make sure you end it in the chat right here.
So one question is, can an irrevocable special needs trust be amended if you just want to change the trustee? So again, the trustee is the person or organization that is going to run the trust. They're going to manage the assets inside. They're going to make decisions. They're going to make distributions. And they are the final decision maker of the trust. So that question is going to be the answer to that question is a little bit dependent on the structure of it. So many times if you do have, sounds like you do, a standalone irrevocable special needs trust, and you may be, as a parent, if this is the parent speaking, if you set it up, you might be the initial trustee. So many times attorneys do write language in the trust that allows the existing trustee to, make adjustments to successor trustees. And the reason they do that is, especially if you're using a company as one of your trustees, and let's say that company, or that financial institution goes out of business, or they no longer provide trust services, there needs to be a way that the trustee, or another person inside the trust can change that. And so usually there is language in there for you to do that. I would just review that language, but normally, yes, you can change just those, those minor things inside that trust.
All right, Ryan. Someone's asking, what's the right age for the child when the trust should be set up? And how long does it take for the process to create a special needs trust?
So what I would say to that is, depending on when your child has a diagnosis, whether what that diagnosis is going to lead into in reference to their development and ability level, I would recommend and suggest that you go set up a special needs trust as quickly as possible. At least get the legal document done. You might not put any money in it yet, right? You might not fund it, but at least it's there and going to be able to receive dollars. The reason for that is, again, if you pass away and your child's only 6 or 7 years old, and if they get a lump sum of money, then they would not be able to qualify for some benefits before the age of 18. If all of a sudden they received that lump sum of money, or the special needs trust received it, well, now they could be open to all sorts of different benefit programs right at that moment of you passing away. So what I would say is you want to set it up immediately. That when your child has a diagnosis, and get that done. It doesn't necessarily take very long to get a special needs trust created. Usually, it may take 2 meetings with the attorney. So, you most likely could get it done at least within a month, depending on probably your schedule or the attorney's schedule.
Yeah, when I got mine done, it took probably 2 weeks. There was an intake process where they ask you some questions and understand your situation better, and back and forth a couple versions, and then you execute the version. So
Yep.
that's how it worked for me. It was relatively painless.
Yep.
All right, Ryan, go ahead if you see another one you want to grab.
Yes. Let's see. We have one that said, should I keep my 24-year-old's irrevocable trust or change it to a special needs trust? So this kind of lines up with one of the earlier questions about an irrevocable trust that we just mentioned. But it appears from this question that this family has an irrevocable trust for their 24-year-old, but it's not a special needs trust. So the question I have for you on that is, if your 24-year-old is receiving government benefits like SSI, like Medicaid, like maybe a waiver program in your state, then yes, I would suggest that you change to a special needs trust and have that done. Again, so that answer is going to be dependent on what benefits your child receives today and what benefits they may receive in the future. But having it as a special needs trust will allow them to be able to qualify for certain government benefits, where if it's simply an irrevocable trust, they would not be able to receive certain government benefits. So if you want the flexibility for your child to receive, as many of the government benefits as possible that they could possibly qualify for, then special needs trust more than likely would be a better avenue for that purpose.
All right. Is there any benefit in moving funds from a special needs trust to an ABLE account to pay for needs for my child out of the ABLE account instead of the S&T? S&T is special needs trust, by the way.
I would say yes. And we had several questions about special needs trust and what it can pay for, and if it pays for housing, does it reduce costs, things like that. So I'll answer a couple of those in this question. I would say yes, there's a big benefit to moving money from a special needs trust to an ABLE account in small increments. And the reason for that is the ABLE account can pay for things that you're not supposed to pay for out of a special needs trust. And when I think about that, I think of housing costs, rent, utilities, those types of things you can pay for from an ABLE account, but you're not supposed to from a special needs trust. Also, going to the grocery store, all right, and buying food at the grocery store, not supposed to do that from a special needs trust, but you can from an ABLE account. So, and we are able to move money from a special needs trust into an ABLE account. And so that's where ABLE accounts and special needs trusts can work together to really benefit your loved one. So yes, I would say, you probably would want to do that as you're managing their needs, depending on what the costs are and where they're living and how they're living.
I want to give honor and deference to our military service people. There was a question that came in regarding, I know it's sort of narrow, but I want to make sure we be respectful and honor people who served in the military. But he's asking, or she's asking, is a U.S. vet who served in 1973, 79, 76 eligible for a special needs trust through a vet admin? We currently live in North Carolina when my husband served in New York. So she's just asking what's available for vets. Is there some special needs trust for vets?
It depends on who that's for, right? If it's for if it's for the individual who actually served, right, that they have a disability and they're receiving benefits. It just depends on if they're receiving disability benefits from the military. If they are, it's probably an income stream that's in excess of qualifying for SSI and Medicaid. So they would more than likely be on a military disability benefit plus what's called TRICARE, which is kind of the healthcare, long-term support and services benefit from for veterans. If it's for if the benefit that they're looking for is for their child that has a disability, then yes, there is a specific type of special needs trust that can actually receive what's called the survivor benefit pension, or SBP, from a veteran's military pension. So it just depends on who they're asking for. If they're asking for, again, their child with a disability, then yes, there is a specific special needs trust that they need to look into, that they can actually house the survivor benefit pension at the death of the veteran, that can go for the entire life of their child without limiting their ability to receive government benefits like SSI and Medicaid.
Okay. Let's see here. And my vision's bad. Where is jurisdiction of a special needs trust, and how does it need to be set up so title for a house in Kansas can be transferred? Is that going to be too specific for you, Ryan?
Repeat the question again. Sorry, I was finding questions also at the same time. Our fault.
Why don't you go find one, and I'll look through this question, see if there's a way I can summarize it for people. Do you see one that you want to answer?
Yes. Yeah.
Why don't you go ahead and do that?
So this question is, will an SNT funded by an inherited Roth IRA see through the trust to the beneficiary to determine how long the IRA can be stretched? Disabled beneficiaries still have the ability to stretch as an exception under the CARES Act. So that's kind of a loaded one. One, a Roth IRA, it doesn't have that requirement. An inherited Roth IRA doesn't have a requirement to take the money out. And the reason is because the person who funded the Roth IRA used after-tax money to put into a Roth IRA. So therefore, the Roth IRA is completely tax-free to the person who contributed money to it, and then to the beneficiary of it when the owner passes away. So there is no, and the reason for that is the government doesn't care if you keep the Roth IRA as long as you want to for generations and generations, because they've already received their tax money on the contribution. The only reason there's a stretch or the 10-year rule of distribution from an inherited IRA is because the government did not receive their tax money on the contribution either into a 401k, 403b, or into a traditional IRA type of situation. So for Roth IRAs, you don't have to worry about it. There's no stretch. There's no 10-year rule, nothing. You can keep that money inside the special needs trust as long as you possibly want, because it's not going to be taxed at all.
All right. And there's been a couple questions that popped up relative to what is a permissible distribution. When you get the replay, I'm going to include a link. If I can find it during the webinar, I will post it here so you can get it. But if I can't find it right now, then I will. It'll be attached to the replay, the replay webinar when you watch it later. Just look for a link that says permissible expenses, something like that. We've shared it a few times in the previous webinars, and I should have thought to include it here, but I didn't. Here's a question from someone's asking, how can a widow shelter her financial resources intended to be placed in the special needs trust for her adult child in the event of a long-term illness, where she may be forced to spend down her funds, hence leaving little to the special needs trust? That's a tough one.
I saw that one too, Keith. Yeah.
I want to avoid it.
No, absolutely not. Nope. So again, that's a good question. There is a rule with Medicaid and special needs trusts that allows an individual, like a parent or a widow in this case, where you can move your countable resources into a special needs trust for a child, for the benefit of your child with a disability, and actually qualify for Medicaid the next day. So there's even no look back period. So, and that's a strategy for some families, especially if you have one child, or, you're going to give all your resources for the support of that one child. You could kind of wait till the last minute, or, until you have to qualify for Medicaid for your own long-term support and services. So you don't have to whittle down your countable resources, which is, it's just savings accounts, investment accounts, rental properties, things like that. You could transfer ownership of those things into the special needs trust when the time comes, and you could actually qualify for Medicaid themselves at that.
Hey, Ryan, I'm going to put you on the spot here. Sorry about that, but I'm getting a ton of questions there. We still have a ton of questions here. Could you allocate some of your staff to maybe go through later and help answer some of these questions on the replay that we're not going to be able to get to? Can we try to get some people that can help answer some of this stuff? Because there's no way we're going to get through all these questions, and I don't want to do that disservice. So maybe Andrew or someone can get on there and do some quick answers for some stuff you think possible.
Yeah, or we'll do another one of these, and also what I was also thinking is we'll also do some quick videos on these questions, and then we'll email them out to our list, right? And we'll just do kind of frequently asked question videos, and then get them right out within 30 seconds to a minute answers.
All right, we'll try to get all you guys' questions answered best we can. We're getting a lot of them in. I see there's a lot of interest in this, so we appreciate that.
Yeah.
You got any other ones you want to grab out of the special needs trust, Ryan?
That's what I'm looking for here. I know we tried to organize them as best we could, everybody. Let's see.
Next time I do it, I'm going to ask people to ask questions by organization topic. That way I would have only been looking here, because right now I'm going through all of them and trying to see which ones are related to
here's a good one on special needs trust and kind of the need for it. So if a child with a disability is named in the special needs trust, as has a special needs trust, but then is capable of supporting herself, is it a good strategy to put some but not all of her inheritance in that special needs trust so that she has more leeway with the funds that are outside of the special needs trust? So just to say that in a little bit different way is, you have a child that has a lot of ability and may be able to work in the future and maybe support themselves completely. Do we use a special needs trust for a portion of dollars that you want to leave her for inheritance, and do we leave some outside? So the answer is you certainly could. The issue with that is that if she all of a sudden isn't able to support herself, then because that money sits outside the special needs trust, she's not going to have any of those government benefit support net, right? And so it just depends on your feeling about how you want to plan. And what I mean by that is, do you want to plan to make sure there's a safety net on the worst case scenario, or do you want to plan more on the best case scenario of her being able to completely support herself without government benefits? The one positive piece, about a special needs trust is, obviously it has language in there to, avoid counting as a resource for qualification for government benefits. But if your daughter, in this case, doesn't need those government benefits and all the money's in a special needs trust and she's not receiving the benefits, it doesn't have them, well, the trustee can still use that special needs trust as kind of a regular trust, but ignore the rules of distribution surrounding government benefits and government benefit qualification. So you can do that with a special needs trust. obviously it's, if you start doing that, then, qualification for government benefits on that side will be challenging as well.
So I'm going to summarize the question here, make it general for everybody, because this is helpful. But the person who's asking about that has 3 different states, Kansas, Florida, and California. It's too specific to handle here directly, but the question I'd like to generalize to you is, when you do a special needs trust and the child lives differently than the potential guardians, is it better to do the trust where the child's living or where the potential guardian is currently living, assuming that they might live in different places?
Yeah, it doesn't matter.
Okay.
It really doesn't. I mean, the one thing that you want to do is you really just want to have it set up and have money placed in it, even if it's just $200 or $500, before you move out of state, or before the individual with the disability moves to a new state. It really is dependent on what's called the grantor, and that's people who are setting up the trust and where you live, not where the individual with the disability lives. So when you're first designing it, it really needs to be set up in the state that in this case, maybe the parents live. And that's where the trust needs to be set up originally, is where the parents are living at the time of setting it up.
Can you tell us can the special needs trust administrator and the trustee be separate? Is it administrator and trustee the same?
Yeah, I saw that question too, and I'm not sure exactly what they are.
But they're the same in that case. Maybe she's referring, or he or she's referring to a guardian of that, because I think the administrator and the trustee are the same, right?
I mean, yeah, it certainly can be. I mean, you would think, I always talk about kind of a family member trustee, and then maybe a administrative trustee, right? And kind of the family member is the final decision maker, but the administrative trustee is handling kind of all the administration of it. So you could have both of those things inside of a trust, and they would both be different. But if you just name a trustee, that trustee is going to administer the trust.
Okay. So if I'm understanding correct, if my memory is right, there's the guardian who's managing the person's life, day-to-day stuff, and the trustee who's handling the finances and who should be knowledgeable about, or not should, must be knowledgeable about special needs law and all that kind of stuff to make sure they don't, do something to invalidate the trust. Right. That's why you're talking about it might make sense to have a family trustee who relies on a professional trustee who's aware of all the laws. Is that what you're talking about?
Yes. Yeah.
Sort of like I have my setup with my first party trust, is that I have the administrative trustee who's, doesn't know my kid at all. And then he has his trust advisors, which are me and other people collectively to talk about that.
Right.
Okay.
Yeah. Yeah, absolutely.
All right. I'm going to grab a couple questions from the chat. And then we're going to move into ABLE account to do that. Somebody's asking what guardianships are required for ABLE and S&T.
There is no guardianship that is required for an ABLE or special needs trust. So an individual does not have to have a guardian in order to have a special needs trust, and does not have to have a guardian in order to have an ABLE account either. Okay. So they're all mutually exclusive from one another.
Okay. Anne is asking, are special needs trusts and supplemental needs trusts the same thing?
Semantics, Anne, semantics. I like it. And so again, people use the word special needs trust as a catch-all for those things. But you're right. Yeah, we should be more specific. So, sometimes folks and attorneys will write special needs trust on what's called a first party trust, which is the individual's money, the individual with the disability's money. maybe from a lawsuit or from an inheritance that wasn't done right. And they have a first party special needs trust. And many times those type of trusts are actually listed and they're actually named, right? The John Brown Special Needs Trust.
Right.
And that would let everyone know that it's a first party. And then there's third party special needs trusts that, yes, are going to be called supplemental needs trust. And third party special needs trusts are going to be everybody else's money other than the individual. So parents would put their money in there, aunts and uncles, grandparents, those types of things. And those trusts, you have a third party trust, or you should, because the name is going to be John Black Supplemental Needs Trust. So you will see those two differences. So, we use the special needs trust term as kind of a catch-all, but it's also specific to a first party special needs trust.
All right. Lee is asking, I'm curious about this too. Does a trust drawn up in Illinois, revised in Wisconsin, follow Illinois or Wisconsin law? So it was drawn up in Illinois, revised in Wisconsin. So which one governs? Or is that a legal question? I don't know.
Yeah, it's definitely a legal question. I would say your Wisconsin attorney would hopefully have told you that. But don't take this as total with total, I guess.
Don't hold you to it.
Yeah, don't hold me to this one, but wherever it's revised last is probably where it's going to be held.
That makes sense, because the attorney would have had to consider the fact that it was drawn up in a different state. So,
right, and then they probably more than likely revised it to hold up under Wisconsin law, or else they wouldn't have revised it. So I would guess just by the timeline that it would follow Wisconsin law at this point.
Yeah, I agree. All right, Mina is asking, could you talk a little bit about pooled trusts started by the disabled adult when they start collecting too much SSDI after death of a parent? Can they do it themselves, or do they need to have a power of attorney to the parent to do this?
So it depends on if they are their own guardian or not. If they're their own guardian and they're under the age of 65, they can start their own special needs trust. However, what I would consider if they qualify, and this might lead into a bunch of other questions, which we have questions on, I would consider putting their money in an ABLE account instead of a, specific either first party or into a pooled special needs trust. If it's less than $15,000 that they're saving every year from the additional SSDI payments, I would consider using an ABLE account instead. It'll keep everything much simpler and much easier to administer.
And probably less costly.
And much less costly to administer.
Hello, Velvet. I met Velvet on YouTube. I see her. I'm going to get to your question in a second, Velvet. Belinda is asking, can you find an attorney to help set up a trust in North Carolina? You can talk to Ryan. His firm has an attorney who can help out with that. Yeah. Velvet is saying, I was told that I need a special needs trust because I'm getting a settlement from a case. She has, is it good to use a nonprofit organization who will have control of the trust? So if she's going to get a settlement, I'm assuming, Velvet, you have a disability. I guess that's the first assumption.
Right. If it's certainly if, Velvet, you have a disability, you're getting a settlement to yourself, then yes, you should have an attorney draw up a special needs trust, for you. It depends on kind of the amount of the money that you're going to be getting the settlement on. If it's a smaller amount of money, let's say, $100,000, $150,000, then certainly you could use one of the pooled trust companies that might be, again, more cost effective for you because they're pooling everybody's money together to get the kind of price point that would make sense for that level of trust. If you're getting a settlement of 500,000, 700,000, I would probably do that with a private trustee.
Right. She's in California, I know, because I've been chatting with her. Velvet, Golden State Pooled Trust, run by a guy named Stephen Dale. They can help you with the pooled trust if you decide to go that way. Golden State Pooled Trust is one we've worked with in the past, or had on here in the past. Lynette is asking, I'm going to answer this real quick because it's quick. Lynette's asking how to set up an ABLE account. Lynette, there is a website that I cannot think off the top of my head. I should probably have that memorized by now. But if you just type in ABLE account and the name of your state, you could find the ABLE account that's set up for you, but you can use other states as well. So I want you to be aware that you could, decide that you want to get your ABLE account in California. Most of the states, not all, allow you to have open out-of-state residents to do it. So,
yeah. And the website Keith is mentioning is ABLE, N as in Nancy, R as in resource, C as in center.org.
There you go. Ryan, you are super helpful. So I would go there, and it's got a great little research tool that lets you decide what's important to you, and then these are the ABLE accounts that meet that criteria, and then you can decide which one's a good fit for you, Lynette. All right. Humana says, my parents want to leave their house for their daughter. They have been on Medicaid for over 12 years. I was told that if the house is going to a child or a grandchild that is disabled, Medicaid loses their right to get paid. They said that the house is there for the child to live in, and even if they do not live in it, there is a potential for them to at some point in their life, and that is why Medicaid loses their right to the house. Could you please let me know if this is accurate? Must my daughter live in that house?
So good question, and so part of that is yes. Right now, with the rules that if you're leaving the asset to a child with a disability, then yes. I would have to confirm the second part of if they don't live there. I was under the impression that they'd have to live there, for it to not count as an asset for them. Because if it's one of the things is that if it's not their primary residence with Medicaid, that then it's a countable resource. So if not living there, it wouldn't be their primary residence. So that's something that I'll have to go check to see if that part would be accurate.
We're going to go ahead and move to ABLE since we had a couple questions on that. What happens to the funds in an ABLE account when an individual passes? I assume the individual with the disability passes.
Yeah. And so it's going to really go to whoever is really the next of kin, I guess I would say. Most ABLE accounts, you can put a kind of a note on who that would go to. Again, it's first going to go to almost all of them, as we know, have a Medicaid payback, at least from a federal level, and some states have waived that. So it's first going to go there. And then it usually would go to, usually the ABLE accounts have like an authorized agent or authorized representative on there along with the individual with the disability. So it would more than likely go to that person.
Is an ABLE checking account taxed? And how you go about creating them is the second part. Go check out that website Ryan just mentioned. There's a great resources of all the different ABLE accounts. It's updated, so I would go there, and that's how to do it. When I opened mine, it was very, very simple. Here's an application, fill out information, provide your proof of who you are, and send them the deposit, and you're good to go. So it's really simple to do. It's pretty much like a bank account, but a little bit more complicated, but not much. So is it taxed?
It is not taxed.
I did not know that. Okay.
It is not. That's one of the benefits of an ABLE account, is that it is not going to be taxed.
All right. If my adult son, 22 years old, receives SSI, is he able to save some of his SSI in an ABLE account?
Yes, they can. Yes, individuals that receive SSI can certainly contribute to an ABLE account and can contribute that money to the ABLE account.
Someone's asking, is there a best time to open an ABLE account? And I'll answer that one now or yesterday. It's really easy to do. It gives you a lot of flexibility about how to provide for, take care of your child. And more importantly, it gets it out of the way for the next caregiver. I mean, so it's already set up, it's already available, and you've already set it up in your lifetime versus someone who comes in after you trying to do some of the things that you didn't get to. So it's easy to do. It's easy to set up. It's a good way for you to have people who want to give your child Christmas gifts or whatever. You know, they can make it out and send it to the ABLE account, and it goes there, and you can use it as pretty much however you want for your child's benefit. So I would encourage you to get one. Everybody should have an ABLE account, in my opinion. You want to add anything to that, Ryan?
Nope. I think you hit it on the head.
Yeah, I mean, I'm so glad I got mine. It's just so much easier. My brother and sister make donations or not donations, they give him a Christmas gift, goes in the ABLE account, and I use it for whatever he wants to do currently. So it really works out. Someone's asking, how do you properly label the ABLE account on the annual SSI review so that we're not asked months later to explain those assets? ABLE accounts, our understanding, do not count toward our child's assets resources, correct?
Yes. So the benefit of an ABLE account and a special needs trust is any assets held in either of those accounts are not accountable resource for qualification for government benefits such as SSI, Medicaid, and any state waiver programs.
Do they ask about that at the annual review about his ABLE account?
They not yet. They're still asking about special needs trust, so they will eventually.
Okay.
I haven't seen them ask yet, but I'm sure that'll be something that they'll add to the list eventually.
All right. Can SSA ask for any funds to be returned from the ABLE account? Is that Medicaid payback thing?
That's what I was thinking, is that, you know, they can't ask to be returned any money from any income sources. So for example, like SSI, right? So if your child received SSI as an income stream, but didn't really use much Medicaid, you know, they can come back and get repaid for the SSI, right? That's not what they can get repaid for. The only thing they get repaid for or reimbursed is for actual Medicaid services and the cost of those services.
Okay. If we have an ABLE account, can we still have the waiver program, or would we lose his services?
One of the benefits to the ABLE account is, again, it is not a countable resource when thinking about any government benefit that has a financial qualification. So the Medicaid waiver benefits are included in that. Supplemental security income is included in that, and Medicaid in general is included in that as well. So if your child does have one of the state waiver programs, you can certainly still use an ABLE account, and that's a safe account to build money in for them.
I'm going to go answer a couple questions from the chat over here, and then I'll get back. We'll move over to government benefits, and then we'll finish up with miscellaneous types of things that I wasn't able to organize. Anita's asking, I'm 60 and I want to save money, but I'm on disability and don't want to lose my food stamp benefits and Medicaid. I already have an ABLE account. I'm not sure there's a question there. So no.
I would say keep saving in the ABLE account.
Right. Let's see here. Barbara's asking, is there a way to help my daughter who's 26 or 27 to qualify for Medicaid? She needs a surgery costing well over $100,000. She does not receive financial aid or dad's death benefits.
Yep. So you would have to, she would have to have less than, at this point, $2,000 in countable assets in order to qualify for Medicaid. So that's one requirement. And so if that is her situation, and then she also has a low income as well, then yes, you could certainly call Medicaid, your local Medicaid office, and apply for Medicaid.
Is it true, this is a Keith question, is it true that Medicaid varies by state? I mean, California might be more generous than, let's say, Florida as an example? Or
yes.
Is it all the same?
Nope. So Medicaid's a federal program, but it's administered by every state. So each state could administer it differently.
Okay. Someone's asking, for a severely disabled adult child, which is better, able account or a special needs trust? They serve two different roles, I think, right?
The special needs trust and able accounts?
Yeah,
absolutely. So the where you use able accounts is for really smaller amounts of money, because you do have that Medicaid payback for the most part in there. But the other thing that you also have is right now there's a $100,000 value rule in the able account. So if your able account begins to build above $100,000 and your adult child or your adult loved one is receiving SSI and their able account hits $100,000, SSI is then suspended. So they're no longer going to receive that monthly income. Special needs trust has no upward ceiling of the amount of money that can be in there, and any negative impact on any of those government benefits that we've been mentioning. So special needs trust is really used for larger sums of dollars that maybe you fund at one time or a few times during your life, or at the end of your life as a parent. Maybe grandparents put lump sums in there at the end of their life. That's where lump sums would go in a larger amount, and then the able account would stay relatively small, because again, as we mentioned right earlier, almost right in the beginning of this webinar, is you can take money from a special needs trust and put a little bit of it at a time in the able account. So there's no reason to have a ton of money sitting in the able account when you can use both of these tools complementary.
Anita's asking, can anyone with a disability get an able account, or is there an age range?
So you would have had to been deemed disabled by the age of 26. So if you were deemed disabled by Social Security before the age of 26, then you'd be eligible to open an able account. If your disability happened after the age of 26, the able account's not an option.
Okay. And Jacqueline's asking a similar question. Jacqueline, if your son was diagnosed prior to age 26, then yes, you can still open an able account. But if he has any disability, you can open a special needs trust at any age, right?
Yes, right. You can.
Okay. So yes, Jacqueline, you can open a special needs trust at any time, but you have to have the diagnosis of a disability prior to age 26 to open an able account. There is legislation potentially out there, but it hasn't passed yet, but we'll keep you posted if we learn about that. Pat's asking, beneficiaries for our account should go to who? The executor for distribution to all children are into the special needs trust.
So beneficiary designations are important. So thanks for the question, Pat. You really want to detail out exactly where you want that asset to go specifically. So if you want it to go to a specific child, put it to that child. If you want it to go to the special needs trust, write the name of the special needs trust on the beneficiary designation form. You really don't want it to go to the executor, because if you put it to the executor, it's going to basically go through your estate, and then have to go through probate. You really want it to go directly to the individual that you want to have that money, or to the trust that you want to have that money.
And I know that you'd mentioned it within the course, Ryan. It's important. Sometimes the name of the trust is super duper duper long.
Right.
And so make sure, if it's one of those really long names that you can't write it entirely in that line, then you need to talk to your attorney. I know this sounds really crazy, but you need to talk to your attorney to see what's an acceptable legal abbreviation that will work. Because if it's not titled right, it could cause a problem. Is that right, Ryan?
Yes.
So, I mean, it seems like a technicality, but some of these long names are like the Alexander Caldwell Special Needs Trust of 1987, born, just on and on and on. So it's important that you do that. So if you have one of those long names, make sure you chat with your attorney real quickly about what's an acceptable abbreviation that you can put on that line, because sometimes you can't get it all on there.
Yep.
I remember that from the course, Ryan. You see?
That's right. That's right.
Beth is saying, is the 100,000 limit on the ABLE account for a lifetime or the balance limited?
It's nope. So that is just the account value before SSI is suspended. So before that monthly income of supplemental security income is suspended. You can put on every state, because ABLE accounts are administered by each individual state that offers one. So each individual state will have a maximum amount you can contribute. They're going to range probably anywhere from the high 200,000s into the high 400,000s in terms of the total amount that you could contribute into an ABLE account over your lifetime. But that $100,000 number is the number that will impact SSI, that monthly income. You can certainly have more than that. You just won't receive SSI anymore, as long as it stays over the 100. If it drops back down to 90,000, then you can call Social Security and try to get that reinstituted.
I'm going to grab 3 questions and I'll answer them in the interest of time, because they're ones I think I can answer.
Yeah, baby.
Check me if I'm right. Tammy, Marilyn, and Cindy are asking, can you have both an ABLE account and S&T? Yes, you can, and yes, you probably should. And for various reasons, they serve different roles. One's a much larger amount, and I use the ABLE account to do the day-to-day types of things that happen. Can you open an ABLE account online as Maryland? Yes, you can. At least in California, I did it all online. There was no place to go to. And then Tammy saying, when the person passes away, is the S&T payout the same as the ABLE account, or will it go to the beneficiary listed? And that depends on the first party, third party, right?
Yes. So it does depend on first party or third party. If it's a supplemental needs trust, right? Third party, meaning it's the parents' money or grandparents, but it's not the individual with a disability. Then the special needs trust, you have already dictated, if you wrote the special needs trust, who you want the beneficiary to be after your child with a disability. And so for that third party trust, any money left in the trust will go to whoever you want it to go to. And so there's no payback to Medicaid in that third party supplemental needs trust. If you're looking at the first party, then it works the same way as the ABLE account. The only other benefit with the special needs trust, the first party special needs trust, even though it works with the same Medicaid payback provision, there's also another beneficiary that you can write in there, or the attorney wrote in there, that if there's money left over after Medicaid, then it goes to this person, right? Or to these people, or to this charity. So there's actually a spot for that in a first party special needs trust. But again, if it's a third party supplemental needs trust, you dictate where it goes, after your child with a disability passes away.
Ryan, can you tackle this real quick? I think we answered it. I just want to make sure we're clear. Judith is asking, my adult independent daughter lives on her own, has an ABLE account and an unfunded S&T. Should us parents, guardians fund the S&T over the ABLE? I understand that the ABLE funding reverts to the state at owner's death to repay the services rendered.
So depending on what you're doing, if you're just putting $500 in there for her to use this month, or for her to use next month, put in the able. It's just, again, makes your life simpler, makes her life simpler. If you're talking about funding it with 25,000, 30,000, 300,000 at different times, then fund the special needs trust with that money.
Right, because of the larger amounts.
Right. And the other part of that is larger amounts, Keith, and she's not going to use that in the month or in 2 months. So if something bad happened to her and she passed away, well, then all that lump sum of money you just dumped in the ABLE accounts going back to Medicaid instead of going to where you want it to go to. So if that large lump sum is sitting in the, special needs trust, then at least that money can go to whoever you want it to go to.
This might be illustrative for people, is that I have my first party trust that was part of a settlement. I have the third party trust that I set up. And then I have the ABLE account. So order of spending, I try to spend the first party trust money first, because I know that's the one that's going to get, they're going to come back for Medicaid repay. And then my third party one I use last, because I want that to grow, because if the first party never runs out of money, the third party can get bequeathed, I guess, to whoever I want it to, my other son, or if I want to gift it away, or who knows. I have flexibility, but I know the state's going to come back and get the money on the first party trust because that's part of the rules. And then I go to the ABLE account because that gives me more flexibility. And the third party is the one that I'm going to let grow, because unless I need it or he needs it, it can go to the next generation without any hindrances, right?
Yes. Yeah. As the rules are today, you have it exactly correct, Keith.
As the rules are today. That's right. Marilyn's asking, we have 4 children. Should in our will we leave money to our daughter's S&T account, adding our son's name? Also, who will take care of her? It's the adding of names that concerns me. What do you think?
So in your will, you can certainly list whoever you want to receive your money. And so certainly in your will, instead of it going to your daughter directly, I would absolutely name her special needs trust for whatever share you want her to have. Again, part of what you might mean is, how much do we leave to the special needs trust versus your son, who might be one of your sons, or your only son might be the caregiver for your daughter with a disability. And so that comes down to what we call the fair and equal conversation, right? When you have 4 kids that, all have the same ability level, you leave all your money pretty simply, 25, 25, 25, as long as they're all nice to you, right? But when we have one child with a disability, they might have more support needs. And then if we have one child who's going to provide those support needs, right? And then we have 2 kids that aren't going to do anything. Well, maybe that equal 25% to everybody isn't really fair. And that's part of kind of a planning conversation and brainstorming with you to determine, okay, what does my child's living arrangements look like when I'm not here, right? Where might they be living? What are those costs? What is Medicaid and government benefits paying for? What are they not paying for? Who's doing the caregiving and the oversight? Is any of that paid by the government, or are we going to have to fund it? And so, for example, if let's say you have one son who's going to care for his sister, if you died, is your daughter going to go live with your son and his family? Does that require your son to add on to his house? Does it require him to move to a bigger house, right? If so, then maybe he has to get a little bit more than the other 2 that aren't disabled and aren't helping, because he needs to make adjustments to his house in order to provide for not only his family, but now his sister, or do you leave money to a special needs trust? She's not going to live with the brother, but he's going to be the trustee and the caregiver oversight. Well, again, if your special needs trust is written correctly, the attorney put in the special needs trust language that the trust can pay a fair wage to the trustee and to caregivers. That means the special needs trust can pay your son for either caregiving or for trust management, but then also pay for everything else that your daughter with a disability might need. So really, it comes down to a conversation of what does life look like for everybody in that situation, and what do your assets look like to be able to provide that funding?
Let's go to guardianship real quick, okay?
Yes, I have some of those up in front of
And
me.
I see some questions coming in, guys. We're going to try to get to them. And we're going to go a little bit longer than we normally do because I want to try to get as many of these done as possible so that, we're being fair.
And maybe we do another question and answer period in the beginning of March. I mean, we have a lot of them, so we're good with that.
Okay. All right. That's always an option. The last woman who brought that question, I would add that if you're going to make a differentiation between what you're going to give the kids differently, I would just have that conversation with your kids in advance. Because when I told my oldest son that I was going to give more to my son who has a disability, he's like, oh, I totally understand with that. I can just see him finding out at the will reading that I gave his brother all this money and being a little resentful. So that's what I did. I just thought it made sense just to say, hey, I'm going to give your brother more because he's going to need it. And, you're not going to need it as much. So that's just my opinion. I mean, you can do what you want, but I think that's a good idea. So Ryan, talk briefly about, are there various options for guardianship? And me personally, my son's turning 18 next year. I'm starting my guardianship paperwork this year because the courts are closed and it's a mess, and I want to make sure I have enough time. So if you want to, be part of that, then we can all talk about how we do it together. Because I know there's several of you guys are going to the same spot, so we can all learn together on that one. And we'll pull on Brian's head. So what's is there varying levels of guardianship or different things that guardianships are? What is guardianship?
Yeah, and so one, and I saw some questions on there about, when do we start guardianship? And I always say, and I've always said in the past, at least by 17 and a half years old. And like you said, Keith, maybe a little bit earlier now with kind of the backlog that COVID and the closing of courts has caused. Because what you want to do is you want to make sure you get the guardianship paperwork. Again, in some counties and some states, they make guardianship really challenging for folks. And so in those situations, I saw some questions about, do I need an attorney or not? I would say in some areas of the country, you probably do. In some areas of the country, you could probably do it yourself.
It was pretty easy for my friend Paul to do it.
Yeah, and also it also depends on your question, Keith, about are there different levels of guardianship? Mm-hmm. And that comes down to your child's ability level. One of the questions that I always receive is, well, if I do guardianship, I've heard that they strip my son or daughter of their driver's license if they're able to drive, and their driving privileges and those voting privileges and those type of things. And in general, that would be true. But in actuality, it doesn't have to be. So you can actually carve out someone keeping their driver's license ability, right? Or their driving ability. And so if your child has certain levels of ability that you want to make sure certain things are still allowed to do, then I would say you probably want to go talk to an attorney to make sure that they help you carve out those different pieces. Because you can, there's obviously, you can have just general guardianship. Your son or daughter's never going to drive. They're probably not going to vote. They just don't have that the ability to and capability to understand all those things. Then if your jurisdiction allows it to be pretty easy, you could probably do guardianship by yourself. Again, you call the clerk of courts, you ask for the guardianship papers, they send them to you, and you just start working on that packet. If it's a little bit more where you want to carve some things out, I would talk to an attorney in your local area. Google, guardianship attorneys in Sacramento, right, or wherever you are. And you know, one of the other questions that I saw is, you know, do I do guardianship versus powers of attorney, or what's the difference? And it's really, you know, I thought we had a really good question that an attorney asks, and they say, really, you know, what is your child's capacity to make decisions? Because power of attorneys, financial or healthcare power of attorneys, have to be signed by the individual. So the question is does your son or daughter have the ability to understand, the capacity to understand what they're signing? And if they do, then maybe power of attorney is an okay direction for you. Guardianship means that they don't have that capacity to make financial decisions and understand the impact of them. Guardianship might also be, you know, they need help in terms of making medical decisions, and not only help, but they need someone to make those decisions for them. You know, so that's really the difference, you know, between the two. Power of attorney doesn't come into play until the individual doesn't have the capacity or capability to make those decisions. You know, one of the other questions that we saw a lot repeated a few times in the questions you guys sent in was, well, if I do guardianship and my son or daughter continues to develop, right, and all of a sudden at age 30 does have the capacity to understand these decisions, to make their own medical decisions, to make their own financial decisions, and they're comfortable doing that, you're comfortable with it, you know, how hard is guardianship to be reversed? And you kind of go through the same process back again to the court system and say, listen, this is what's changed since since I was awarded guardianship of them. And as long as you can show that they have continued that development, their life is different, they're taking on more responsibility, then we have seen guardianship be reversed, and those rights restored to the individual. So guardianship is not necessarily written in stone when they're 18 years old.
And I recall you brought up once before, Ryan, that the difference between POA and guardian, technically legally, is if your son or daughter who does not have the capacity to sign something, then that cannot be held against them legally if he's under guardianship because he doesn't have the capacity to. But if it's POA, he can sign on something and be liable for whatever he's signing, right? Is that distinction too?
Yes.
All right. So that's something to think about too, is if he doesn't have the capacity, guardianship is probably what it is, because he could theoretically get himself into some challenges with the POA only. I'm saying he because I'm talking about my son. So.
Yep.
All right. So someone's asking, my son will be 18 and 9/21. He is not able to manage his own affairs. And how do I establish guardianship myself? I'll give you a brief summary. If it's a man or woman, I don't know. He said he can't afford to hire an attorney. In California, I went to the Superior Court, and then they have all the forms listed there. So if you're in California, you look for the Superior Court in your county and just look for guardianship. If you're not in California, just type in the guardianship, your state. It'll pull up the court. There'll be court documents there. There'll be instructions. I mean, they're dense because lawyers have to be lawyers, and they just make everything tiny and hard to read. But we can
do it.
You can power through it. You don't, unless you're one of those areas that Ryan was talking about that makes it really difficult. You can probably power through it, because I'm going through the same thing myself, and I'm just as frustrated as some of you guys are too. All righty. Hope it's okay to go on, everybody. So we're going to go and tackle a few more of these. And thank you for combining some questions, Ryan, in the response. So it makes it easier. There was a couple government benefits ones I want to address. Please explain how a parent taking Social Security impacts an adult working child's SSI.
Yeah. So again, if your son or daughter was deemed disabled before the age of 22 and is receiving SSI, supplemental security income, then they are eligible for what are called disabled adult child benefits on the parent's Social Security record. So what does all that really mean? Well, I'll give you an example.
Okay.
So let's say a parent retires at their full retirement age and they receive $2,000 a month. And they don't have a spouse that's going to take a spousal benefit. Well, if your child again has received at least one payment of SSI and was deemed disabled before the age of 22, they would be eligible to receive 50% of that $2,000 Social Security retirement benefit, which is more than SSI. Mm-hmm. So the SSI would be replaced by this disabled adult child benefit from a parent's Social Security retirement amount. Now, that does not change the amount the parent receives. So it doesn't decrease the parent's Social Security income. It adds to it because there is a maximum family value for Social Security on one person's record. So let's say that same person is married and their spouse never worked, so isn't going to receive Social Security retirement benefits. Well, they're also eligible to receive a benefit, so it's called a spousal benefit, from Social Security on the record of the working spouse. Now, that means that that spousal benefit is also 50%. But there's 180% maximum family value. Poof! What is Ryan now talking about?
Exactly.
Right? So that means that the non-working spouse and the disabled adult child have to share that 80%. So neither one of them are going to get 50%, but maybe they get 40% of that benefit each.
Okay.
So again, it just depends on the situation in terms of the exact dollar amount that might come in.
My son doesn't receive any government benefits at this time. When do I begin the process of applying, before or when he turns 18?
Well, it's a good question. So one, I would look into what's called the state waiver programs in your state. And so you can Google Medicaid waiver programs in Illinois, in Wisconsin, in California, in Arizona, to see in your state what waiver programs might be available for them. And then call your either division of, Health and Human Services or, whatever that might be called in your state, to apply for those waiver programs now. Because there's usually a waiting list for certain waivers. Some waivers there aren't, but some waivers there are. So you want to get on that right away. And then more of the adult Medicaid pieces like supplemental security income and Medicaid, you have to wait now until the first day of the month after they turn 18. So two answers to that question. State waiver programs, do now. SSI and Medicaid, you have to wait till the first day of the month after your child turns 18. But you can prepare ahead of time by making sure that you have the psychological exam done and that report. Make sure you have the right proper medical records. Make sure you have maybe a copy of the individualized education plan if your child has one. The things that show what their disability is and why they need these benefits and why they will continue to need them throughout their lifetime. And so again, if that's something that, you need help with, what I would say is, go to a specialneedsplan.com and go to the transition planning area. And there's some information there about that.
All right. Someone's asking about, my son currently has TEFRA Medicaid. Will that change at 18? Is there another type of Medicaid that I need to apply for him?
So that's actually a part of the last question, which is great. TEFRA is a waiver program, or considered a waiver program in South Carolina. And so that's a state waiver program. And so, yes, whenever you're on a state waiver program under the age of 18, you still at age 18 have to go through the process of applying for SSI and adult-based Medicaid. So you still have to go through that same process, even if you're already on a state waiver when your child's under the age of 18. And so I think we have time for maybe one more, Keith.
Okay.
Then we'll have to go to another session.
Well, I have a question that somebody asked that I would like to ask. And guys, we're going to have another one of these coming up, but because I didn't know the question. We tried to buy life insurance. This is a miscellaneous one. We tried to buy life insurance for our son with special needs, but were denied by 2 insurance companies.
Yeah.
Any suggestions for families with special needs loved ones for paying for funeral burying expenses? We live in a state of Maryland, but I've heard, is it true that you can't have people with disability can't have life insurance policies?
Nope, that's not true. It just depends on the life insurance company. I know there are a few that are better than others, depending on the diagnosis. I know that, Mass Mutual has a specific program that is designed for certain disabilities that they offer at least a small amount of life insurance for that purpose. But it's more, to me, it goes back to a totally different question. Is yes, understand that you want to pay for their funeral expenses and those types of things. But one of the things to consider is, instead of doing a life insurance policy on your child, do you use your money in a different way? Because really, what do you really need to do is we need to fund the lifetime support needs of your child. So more than likely, if you're going to buy life insurance, it should probably be on the parent to fund the special needs trust. And then when your child dies, they can use the money from there to pay for a funeral. Or out in the future, you can do a prepaid funeral expense for your child, which will be cheaper anyway, to possibly do it that way and to pay for it that way. So whenever I see parents wanting to get life insurance on their child, I question whether that rarely makes a lot of sense, because we're worried about when they die. We first need to be worried about them living with enough financial resources. And that requires you to use your money to fund the special needs trust, not their burial. Let the trust figure that out at some point in the future. Again, it's about them living, not funding the moment they die.
I think that's true. All right, guys, we can't get to all of the questions, and I see there's a ton of them still out there, but we went over a lot longer than we normally do, but I see there was a lot of interest in that, and Ryan's got to get to an appointment, but we want to thank you guys all for joining us today. We will endeavor to have more of these questions and answers coming up.
Yeah.
If you guys find these helpful, thank you for that. Any words of wisdom, Ryan, before we wrap it up?
I think, keep the questions coming. Let us know. I think just let us know if this was a valuable format for you, or if it wasn't, because we can certainly still spatter these in here, during different months, if this is a valuable way for you to, get your specific questions answered. Okay.
Everybody, thank you very much. Look for the replay tomorrow. I'm going to be editing it and putting the questions in there. It's a lot of work. Takes a lot of time to do that, but we'll get that ready for you. Look for it in your inbox tomorrow. Thank you all for joining us. Adios, and have a great weekend.